Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the police having a fundamental misunderstanding of their powers and of your rights. And specifically, I'm talking about your right to freedom of expression, what they'd call freedom of speech in the States. So this is an article from the Leduc Now, although it appears to be an official RCMP press release. And it says, Leduc RCMP asks community to give cops the bird this holiday season. Now, the RCMP is, of course, the Royal Canadian Mounted Police. They're the largest police force in Canada. And it notes, who wouldn't want to give cops the bird and not suffer any consequences? This is already off to a bad start, because when you're giving cops the bird, that's the middle finger, this is protected expression. But it gets worse. It says, well, this upcoming holiday season, the Leduc RCMP, in partnership with a bunch of other places, want to help you do just that. For clarity, we're not talking about the one finger wave. We mean a turkey. And then there's a quote. It says, the one finger wave will get you a ticket for stunting worth $567 and a court date, says Constable Sherry Lee Smith, Leduc RCMP Public Information Officer. This is actually public disinformation. Not the greatest. The latter will warm your heart and help those in our community who are in need. Okay, so this is a charitable endeavor, and the actual endeavor itself of giving turkeys to the needy is a good thing. Like, I support what they're doing here, and I'll link below so you can go and see where you can make this donation. So this is a good project. The problem is when they tell the public that the one finger wave will get you a ticket for stunting worth $567 and a court date. So what is stunting? Well, stunting is part of the Traffic Safety Act, and it's specifically kind of a vague section. And because of that, it's often abused to target behavior that police just don't like. So let's have a look at what it says. So this is the Traffic Safety Act, and it says, a person shall not do any of the following, and lists a whole bunch of things, but one of them is perform or engage in any stunt or other activity that is likely to distract, startle, or interfere with users of the highway. Okay, what does that mean? Well, there's all sorts of things that might apply to. Plenty of YouTube pranksters, for instance, might run afoul of this section. But it's not intended to cover anything and everything. There's limits to it. And some of those limits were determined in a case called the Queen and Jones. And this is a case from 1983. And what happened in that case, and I can just show it to you here, although I'm not going to read you the full case, but they note the appellant, who is a prostitute, and I'm quoting here, was walking along 9th Avenue Southwest in downtown Calgary. According to the evidence, when a car would approach her, she would peer into the car windows and motion to the occupant with her head to pull over to the curb. One must conclude from the evidence that the appellant's activity was discreet, since she did not use her hands, but only her head to motion. She's giving people a little nod over. A minor collision occurred between two vehicles traveling down the avenue, and the police constable, who was the only witness called by the Crown, attributed it to the driver of one vehicle looking at Cheryl. The driver was not called as a witness, and if the policeman was standing near Cheryl, I think it would have been difficult to say who the driver was looking at. The constable also stated that there were about 8 prostitutes near that location, and their activities had the effect of causing a backup in traffic. So basically, there were street prostitutes working in a particular area, and there was a car accident. And the problem the police have at this point is that they don't have the evidence to charge them with anything else. So they charge stunting. And ultimately, the court rejected this argument. They said this is not stunting. Because the problem that you run into with this whole notion of anything that might distract people on the road is that could cover so many things. There's so many things that you might turn to look at. And to a certain degree, the driver also has a responsibility to keep their eyes on the road. And so when the court rejects this, they note, the ordinary meaning of these words leads me to conclude that the legislation was not directed at activities that merely drew attention to oneself or excited towards oneself pleasurable emotions of those whose attention is drawn to them. A distraction must be more serious than an attraction. If such were not the case, one could envision everyday activities which would fall within this section, in fear that those activities might divert the attention of some careless drivers. Immediately one thinks of neon signs, a donkey, a movie star, a well-known politician, or children doing cartwheels or selling lemonade. Obviously, that wasn't the intention because, somebody who's really attractive walking down the street, they might turn heads, causes problems. Any sort of famous person walking down the street, if a driver turns and goes, whoa, that person is not stunting just by existing. That wouldn't make any sense, right? So the court says, no, that doesn't apply. But the police often use this to target expressions they just don't like or that the public doesn't like. And this is where you run into some problems. And so one of the cases that addresses this is the case of the Queen in Wells. Now, Wells was convicted of stunting. So you might say, wait, how does this actually help? Well, Mr. Wells was engaged in some interesting activity. He had a particular issue with Stephen Harper, who was prime minister at the time. And so he was driving down the road with a vehicle that had a large sign displaying the phrase F. Harper in the rear window of a motor vehicle. So he put that in his rear view and was driving down the street. Now, this offended or annoyed some people. People didn't really like that he was driving down the street with that message. Some people said, hey, my kids can see this, knock it off. And some people just said, hey, I like Harper, so stop it. Now, every time you hear somebody say that like the F Trudeau bumper stickers and so forth have no precedent, you can point them to this specific case where in fact there was litigation over people driving around with that mark. However, the court determined that the content of his sign and the fact that he was displaying the sign was in fact charter protected speech. It's protected speech, protected expression under the Constitution. And that in fact, because it was political in nature, it's sort of the highest level of protection. So they determined that Mr. Wells could not be convicted simply for displaying the sign. So why does he get convicted? Well, because he was driving like a jerk. He was actually swinging in front of people in traffic and then slamming on the brakes to make sure that they'd see his sign. And that's what gets him the conviction for stunting, is that it's not the fact that he had the sign, it's the fact that at a certain point his driving behavior was such that it was actually interfering with other people on the roadway. But the simple fact of the sign was not enough to do it. And there's another case that we can look at, and we'll look at it really briefly because, this is kind of a quick and messy version of things, but we're just covering the important bits here. And that is the case of the Queen in Pawlowski. And Pawlowski, you might recognize, he got in some further disputes with the government over COVID rules. But at this point, what he's doing is not anything like that because it's 2009. What he is doing is he's doing some street preaching, basically. He's got he's having church services, essentially, and he's trying to minister to the public and he's making noise and sort of attracting some attention. And the court determined that that also was protected expression, but they didn't find a charter violation because what they said is that stunting has to be something that is so egregious or so distracting that it sort of goes outside of the ordinary bounds. And flipping somebody the bird doesn't seem to cover that. It just doesn't. So what would stunting cover? Well, stunting might cover obvious stunts, like if you were, riding on the top of somebody else's car, or if you were dashing through traffic or something like that. It might cover some sort of YouTube prank where you set up like a fake, cardboard cutout in the road to distract or bother drivers. It might cover something like pointing a laser at drivers. Don't do that. That's not cool. Maybe setting off fireworks on the roadway or beside the roadway might count. Any of these kinds of really overt things. But flipping the bird, and specifically flipping the bird at a police officer, is not included. But if you do it, the Leduc RCMP seem to think that they can write you a ticket for it, which is not the law and not appropriate. Quite frankly, I'm going to be saving a copy of this article because if it comes up, I'm going to keep this. I'm just going to have this ready to go. This was a a dumb statement to make from the police. It gets the law completely wrong. And you might say, oh, it's just a joke, because this is... The problem is, it's not just a joke. People do actually get the stunting tickets, and especially they get the tickets when they flip the bird to the police. Because the police like to use it as contempt of cop. And again, that's freedom of expression. Specifically, when you're flipping the bird to a police officer, that may include a higher level of protection as well, because there may be a political element to that speech. If you're doing it because you don't like police, well, that can be a political statement. And you might say, oh, yeah, I disagree with that statement. Cool. Outright wrong or disagreeable political statements are in fact still charter protected expression. The charter protects your right to be wrong. It protects your right to be offensive. It protects your right to be a jerk. Because any speech or expression that is inoffensive and that nobody cares about doesn't need that constitutional protection. So Leduc RCMP, maybe set up some remedial training. And maybe you might want to tell the public, hey, we got this one wrong. It's okay to flip us off. So if you see a police officer and decide to engage in some charter protected expression, I probably don't agree with that expression, but it's your right. Anyway, I just thought I'd share this one with you because somebody shared it with me and it kind of leapt out as, this isn't right. So thank you guys for watching. I hope you found this to be interesting or educational. I also want to thank my Patreon supporters at the $50 level, the CCFR, Canada's National Firearms Association, the Canadian Shooting Sports Association, and Lembas for the Elf. At the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Here's a Coin, Legal Witcher, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time. And apologies if this video is a little unpolished. I'm still rocking a flu, so... but I wanted to make sure to get this one out before it becomes obsolete. Anyway, see you next time.